Our next guest is Peggy Little. She is the Senior Litigation Counsel for the National Civil Liberties Alliance. You can follow all things NCLA at NCLA Legal. Peggy joins us here on Morning Line. Peggy, great to speak with you again. Thanks for joining us here on a Monday morning.
Thank you, Tim, for having me.
Hey, Peggy, would you just explain to our audience, let me ask you this. Do you agree with the majority leader that this is one of the most qualified individuals ever to be considered by the U.S. Senate for a position on the U.S. Supreme Court?
Absolutely. One of the things you look for in a Supreme Court candidate, because there's a lot of politics in these appointments as well, is someone with outstanding legal thinking. I've been looking at Supreme Court candidates now for many years, and the ones that stand out are the ones whose opinion writing, whose legal thinking, whose conceptual grasp of many areas of law stands out from their colleagues. And Judge Barrett is that outstanding. I've read all of her opinions, many of her law review articles, her speeches, studied her background, and she is just as outstanding as her colleagues, friends, supporters, and even some of her political opponents say.
Now, Peggy, when I pull up the Twitter page of the new Civil Liberties Alliance, NCLA, which is at NCLA Legal on Twitter, it says that the NCLA protects constitutional liberties from systemic threats, primarily the administrative state. Well, Peggy, batten down the hatches here for me, because I keep hearing from the talking heads in the national liberal media that Amy Coney Barrett is going to take away our rights because she's going to rule a certain way on Obamacare, or she's going to rule maybe a certain way on Roe v. Wade. Somehow they think they can get inside Amy Coney Barrett's head when nobody else has been able to. And she said, I do have a mind of my own. I respect and admire Justice Antonin Scalia, who was one of my mentors and friends, but my decisions are going to be based upon Amy Coney Barrett's brain, not anybody else's. So tell us, Peggy, with the liberal left and the media running around with their hair lit on fire in the last few weeks about Amy Coney Barrett taking away our constitutional rights, NCSLA is an organization that protects constitutional liberties. So explain to me why you would support somebody like Amy Coney Barrett. My understanding, my feeling is you're probably going to tell me that the left has it all wrong, and Amy Coney Barrett you would think she may not going to, but she has protected our constitutional liberties and rights in the past through her writings and her teachings and her professorships on these issues.
Well, she has, and perhaps the most outstanding example of that is a case called Doe versus Purdue University, where a young man was accused of sexual assault and found guilty by a panel of Title IX investigators at Purdue that had not even bothered to interview him or to hear his witnesses. Worse, they had not even had an in-person interview of the accuser. They simply relied upon a written report submitted to them and concluded that one person's account was more credible than the other's. Judge Barrett took a good look at that record and said, how could you decide one person was more credible when you spoke to neither of them? And so she set aside an order that had dismissed his case and said he has a case he can bring. She didn't decide the issue because it was not at that stage of the proceedings, but she cared a great deal about his due process rights, which is a very important issue on college campuses. But this doesn't always swing one way or the other. I've read several cases where she upheld decisions that found that, for example, a female employee of Costco had been stalked by a male employee. She upheld that decision. She's upheld Sixth Amendment decisions that support a person's right to counsel. There's not a political leaning to her decisions, one way or the other. It's that she reads the text of the law, or the text of the Constitution, very carefully and then applies it to the facts. And that is what all judges should do.
Fantastic. Speaking to Peggy Little, Senior Litigation Counsel for the new Civil Liberties Alliance at NCLA Legal on Twitter. Peggy, this catchphrase of NCLA talks about the threat. NCLA is one of its main missions is to instruct Americans, teach Americans, show Americans, to help Americans recognize the threat of the administrative state. Peggy, it's something we don't talk about a whole lot, but my understanding is it's one of the biggest threats to our democracy. Can you explain what the threat of the administrative state is and how it has adversely affected our lives over the last few decades?
Yes, Americans are 10 times more likely to be brought into court before an administrative law judge who is not even part of the judicial branch of the United States. It's usually a part of the executive branch, so it might be an administrative law judge, say, of an administrative agency. And that judge rules on their case even though the judge is employed by their prosecutor. Now think about that. Your judge is employed by your prosecutor. That doesn't usually end very well. And in fact, the statistics show that in the high 90% of the time, Americans are convicted by this not unbiased judge. And this is a serious problem. Also, there's a doctrine called deference, sometimes called Chevron deference, but it has many names.
Yes,
where
Chevron case, yep.
Even if you're in federal court, which at least is a court with an unbiased, lawfully appointed judge, the judge is supposed to defer to the agency that is bringing a claim against you, or to defer to their interpretation of the statute in the judge's decision. Well, that's crazy because that's an administrative agency that is your opponent, and a judge is perfectly capable of deciding what a statute says or means, deciding what a regulation says or means. They don't need to say that one party gets to be favored over the other in an important legal dispute before an Article III court, and yet that's what the deference doctrine tells judges to do.
Yeah, Peggy, the administrative state has grown by leaps and bounds over the last many decades. These are unelected bureaucrats who do massive amounts of regulatory and rulemaking, and largely, Peggy, unless you have U.S. senators, Congress people, folks on the state level who are paying attention to them, it largely goes unnoticed, but it really affects the bottom line of so many small business owners across this country. It makes their lives more miserable and also makes the lives of individuals more miserable, like you said, when they end up going before these administrative courts. I think President Trump has tried to throttle this back, hasn't he, with his reduction in massive amounts of regulations over the last few years.
That's true. He has issued several executive orders that there was one called to improve due process in administrative adjudication. And the orders generally provide that people have to be given fair notice of what they're being charged with, an opportunity to respond, and also the procedures need to be followed. That's what we like to think of as a baby step because we feel correctly, I think, that even when you're before an administrative law judge, you do not have jury trial rights. You don't have civil procedural protections. The rules of evidence don't apply. And all of the way the process is adjudicated favors the government agency. And that's just not right to Americans. The whole reason we have a separate branch of government in the judiciary is there's an unbiased judge who has life tenure, who takes an oath not to favor one side over the other, where there are procedural protections that have been developed over centuries to be sure that Americans get a fair shake in a judicial proceeding. All of those things are dispensed with in the administrative proceedings.
Peggy, before I let you go, any chance that any Democrats will cross the aisle and support what is an esteemed jurist, as we've discussed with you all morning here on Morning Line, which Amy Coney Barrett obviously appears to be? I mean, they hardly laid a glove on her. There's been you haven't heard anything in the mainstream media. There's been no, like with Kavanaugh, it was just brutal. And, Amy Coney Barrett's hearings kind of came and went. And it seemed Dianne Feinstein even gave her a hug on the way out of the hearing room, which took a lot of grief from the far left lunatics on about. But any indication, Peggy, that any Democrat, like maybe a Doug Jones from Alabama or a Manchin from West Virginia, are they going to any of them going to vote for her, or any of them going to show up, or are they going to boycott this like they boycotted the hearing, the committee vote last week?
Well, it hasn't come to my attention, but I certainly hope someone will. I think it's important. I think that there is not a reasonable case that can be made that she did not meet the highest standards of what you want to see in a United States Supreme Court judge. I think it was, frankly, childish for the Democrats to boycott her hearing. The vote, rather, after the hearing. They had actually threatened to boycott even the hearing, which would have spared us all of their questioning. But I think it would behoove any Democrat to cross the aisle and vote for her. There's no question she meets and exceeds the standards for prior Supreme Court justices, and I think it would send a great signal if a Democrat or two would vote that way.
Fantastic. Peggy Little, the Senior Litigation Counsel for the New Civil Liberties Alliance at NCL Legal on Twitter, giving us all the advance notes on Amy Coney Barrett ahead of her expected confirmation as the 9th newest justice to